Hey everybody, welcome back to the Court of Random Opinion. My name is Lauren Neidigh. We have another update in this whole Blake Lively versus Justin Baldoni situation. This one involves Jed Wallace, whose agency Street Relations Incorporated did crisis PR for the Wayfarer parties. He's accused of being like the orchestrator of this crazy shadow smear campaign, delusional fan fiction. He was recently dismissed from the case, but without prejudice, so Blake Lively filed a second amended complaint. He filed a motion to dismiss that second amended complaint. She, of course, opposed that, and now we have his reply in support of his motion to dismiss. Like the seasons, Blake Lively's efforts to retain jurisdiction over Jed Wallace and Street Relations are ever-changing, from a conspiracy-based theory of jurisdiction, asserted in the spring but rejected in the summer, to now in the fall, a novel theory that Lively had not raised in her prior complaint, but which is now the primary focus of her argument, specifically that Section 302A1 of the New York long-arm statute confers jurisdiction. This change is likely explained by Lively's inability to overcome her pleadings and sworn testimony that the two claims against the Wallace defendants sound in defamation, and thus the conspiracy theory of jurisdiction found in Sections 302A2 and A3 is inapplicable. Her two-paragraph attempt in a 31-page brief to overcome the defamation exception is hardly a response at all. The colors in autumn are so bright just before they lose it all. What the hell? And the change of seasons has not cured the novelty or inapplicability of her A1 argument. A defamation claim is defined in terms of damage to reputation. Thus, New York law considers claims sounding in tort to be defamation claims, where those claims seek damages for injury to reputation, or where the entire injury complained of by plaintiff flows from the effect on her reputation. These are precisely the claims Lively alleges here. Specifically, Lively's claims against the Wallace defendants are founded on her assertion that they engaged in a retaliation campaign that created, seeded, manipulated, and advanced disparaging content about her. This alleged campaign, Lively asserts, caused devastation to her reputation. Further, Lively specifically alleges in her false light and FEHA claims that the Wallace defendants participated in a campaign to discredit and bury her reputationally and publicly made false and misleading disclosures that harmed her reputation. Even Lively's general allegations regarding the actions of the unspecified defendants show that she seeks to redress alleged reputational harm caused by false statements. Lively refuses to substantively engage in this argument, ignores her own allegations, and instead relies entirely on her ipse dixit that neither the false light claim nor the FEHA aiding and abetting claim fall under the defamation exception. Lively also appears to argue that the exception does not apply to her FEHA claim because it is based not only on the Wallace defendants' boosting of negative narratives, but also on their provision of advice and counsel to the Wayfarer parties, activity she asserts does not arguably sound in defamation. Lively misses the point. It is the reputational injury she seeks to redress through her FEHA claim that matters, not the precise manner in which the Wallace defendants are alleged to have aided any retaliation campaign. Under 302A1, a non-domiciliary may be subject to a personal jurisdiction if he transacts any business in New York, either in person or through an agent. Lively contends that the phrase through an agent permits the court to exercise jurisdiction over a non-domiciliary like the Wallace defendants through the acts of a co-conspirator. While this may be true in the 302A2 context, where tortious acts by a co-conspirator are well-recognized basis for personal jurisdiction, it is not the case when, as here, 302A1 is invoked. 302A1 requires an agency relationship in which the purported agent acted purposely in New York for the defendant's benefit and with the defendant's knowledge. 302A2 contemplates a specific agency relationship where the agent is an in-state actor who operates at the behest of a non-domiciliary principal. For 302A1 jurisdiction to exist over the Wallace defendants, the co-conspirators must have acted in New York as agents under the control of the Wallace defendants as their principal. Lively, however, alleges the inverse, that the Wallace defendants are the agents of the co-conspirators. Indeed, Lively alleges that the co-conspirators hired the Wallace defendants and also controlled the Wallace defendants' activities. Lively does not allege that the Wallace defendants transacted business in New York in person. Additionally, the absence of the requisite agency relationship prevents the in-state co-conspirators' alleged business transactions from being attributed to the Wallace defendants. But even if attribution were possible, none of the co-conspirators actually transacted business in New York. The only transaction Lively specifically points to is the co-conspirators' trip to New York on August 4th to 6th to promote the film, consisting of press appearances and attendance at the film's premiere. So that was like Abel and Baldoni and all of them, like Jed Wallace and Street Relations. They never, set foot in New York during all of this. And that's where we saw all those text messages in her response where she was trying to establish that like Jen Abel or Melissa Nathan or one of the publicists, was in New York and about to go to Chicago, which was kind of vague. But alleged co-conspirators' mere attendance at press events and a premiere, activities that rise at most to the solicitation of business, do not constitute transacting business under 302A1. Even if attendance at these few events constituted transacting business, Lively's claims against the Wallace defendants do not arise out of those transactions. Lively does not allege that the co-conspirators engaged in any wrongful conduct during these events, and fails to even discuss this nexus requirement in her briefing. In fact, Lively admits there is no nexus between any New York transactions and her FEHA claim. For this additional independent reason, Lively cannot predicate jurisdiction on 302A1. Even if the defamation exception did not plainly apply, which it does, Lively fails to allege facts supporting a conspiracy-based theory under 302A2. To establish the Wallace defendants' membership in a conspiracy for the purposes of New York's long-arm statute, Lively must allege specific facts showing 1. The Wallace defendants had an awareness of the effects in New York of their activity. 2. The activity of the co-conspirators in New York was to benefit the Wallace defendants. And 3. The co-conspirators acting in New York acted at the direction or under the control or at the request of or on behalf of the Wallace defendants. So for number 1, I'm not even entirely sure that she has definitely established that he knew they were in New York at the time. I know that we saw some text messages, so maybe. For number 2, there was definitely no benefit to the Wallace defendants. And 3, it was the opposite. The alleged co-conspirators were not acting at the direction of the Wallace parties. It would have been the other way around. The Wallace defendants explain at length in their motion why Lively still fails to make this showing, including that she does not allege facts showing the Wallace defendants were aware of overt acts in New York. Lively attempts to show otherwise by pointing to email timestamps, area codes, and Instagram posts. But Lively never alleges that Wallace saw these timestamps or area codes, much less that he understood them to mean anyone was presently in New York. So when it comes to the Instagram posts and stuff like that, especially, it's like celebrities, they'll post stuff and they don't do it in real time because they don't want people to show up where they are. So you never know. She could be far away from New York after posting something in New York. Lively attempts to connect the Wallace defendants to these posts by baldly alleging that anyone engaged in passive observation of the social media environment would have been aware of these posts. She's very consistent in her self-importance, I'll give her that. This is not a reasonable inference, but rather pure speculation that fails to satisfy Lively's burden to allege specific facts, warranting the inference that the out-of-state defendant, not simply anyone, had an awareness of the effects of its activity in New York. Lastly, Lively argues that because the Wallace defendants do not argue they have ever removed themselves from the conspiracy, their alleged involvement in the creation of a website in 2025 somehow constitutes a substantial overt act in New York. First, the Wallace defendants averred that they were not involved in any conspiracy, meaning there was no conspiracy to remove themselves from. Even if the Wallace defendants were involved in creating the website, Lively admits that it only contained materials filed in a prior lawsuit and thus is not actionable. And even if the website were actionable, there are no allegations that this website, or those responsible for its publication, had any connection to New York sufficient to trigger 302A2. So, with the website, the agency that did the website, she tried to subpoena them. I don't know how that's going. I don't know if they've resolved that, but she tried to subpoena communications between, I guess, Brian Friedman and whoever did the website, the agency that did the website. I think it was like Skyline or something, which is just ridiculous because there's only court documents published on that website. She really just is going after anybody trying to find anything, and it's not working. It's not going well. I mean, there were, 2 documents posted on that website, and that's all that's ever been posted there? And as somebody who just got away with a hell of a lot because of litigation privilege, you would think she would understand that she can't just sue people over what's in court documents. What they wrote in their filings, that's not part of a shadow smear campaign. In fact, it's entirely traceable. It's right there. We can show you where to find it if you're confused, which she might be. To satisfy 302A3, Lively had to allege facts showing 1, defendant's tortious act was committed outside New York, 2, the cause of action arose from that act, 3, the tortious act caused an injury to a person or property in New York, 4, the defendant expected or should reasonably have expected that his or her action would have consequences in New York, and 5, the defendant derives substantial revenue from interstate or international commerce. For the reasons discussed above and in the motion, Lively has not alleged any facts from which this court can reasonably infer that the Wallace defendants expected or should have reasonably expected that any act they undertook would have New York consequences. Lively continues to point to the $90,000 the Wallace defendants received from the alleged co-conspirators, but this only shows what the Wallace defendants earned from a single engagement, without comparing that amount to the revenue the Wallace defendants derived from in-state business. Absent this necessary context, Lively has not alleged facts established that the Wallace defendants derived substantial revenue from interstate commerce. Due process is not satisfied. As explained, there are no factual allegations supporting the reasonable inference that the Wallace defendants were aware of the alleged co-conspirators' presence in New York, or that they took any act in furtherance of an alleged conspiracy while in New York. On the contrary, the facts alleged show that the Wallace defendants were blindsided by the alleged co-conspirators' contacts with New York. Because a defendant cannot reasonably anticipate being hauled into court as a result of contacts that are unknown to him, the exercise of jurisdiction over the Wallace defendants would not comport with the due process clause. Lively does not address the most significant relationship test or meaningfully contest that under that test either New York or Texas has the most significant relationship to Lively's claims against the Wallace defendants. Nor does she dispute that the laws of those jurisdictions bar her false light claim. Contrary to Lively's contentions that California law does not require her to plead the elements of a defamation claim in connection with her false light claim, that is what federal courts analyzing California false light claims have required. The mere fact that Lively has not alleged a defamation claim against the Wallace defendants does not excuse her from pleading the elements of a defamation claim in connection with her false light claim. And for the reasons discussed in the motion, Lively failed to plead those elements. Lively's admission that FEHA does not apply to non-residents employed outside the state when the tortious conduct did not occur in California is fatal. Additionally, even assuming the actions of Lively's employer were discriminatory, there are no allegations that the Wallace defendants knew that conduct was discriminatory or for the purposes of retaliation or harassment. Thus, Lively fails to adequately plead an FEHA claim. Because Lively's false light and FEHA claims are fatally infirm, so too is her civil conspiracy claim. We note that Lively has retreated not only from her primary conspiracy-based jurisdictional theories, although she puts up a game front, but despite repeating verbatim large swaths of her second amended complaint, nowhere mentioned is the previously pleaded winky-faced emoji. Nor has she clarified the post, which Lively claims the Wallace defendants must have seen and understood. It depicts Lively under the caption, Blake Lively at Blue Jean Baby NY Lady. Which anyone who has listened to Elton John or watched the movie or seen the play Almost Famous knows is not New York Lady, but LA Lady. The address Lively used when she sued Wallace in Texas. We would concede that the Blue Jean Lady, wherever found, was, in fact, a seamstress for the band. But with all that, the motion to dismiss should be granted. I feel like they always get some funny stuff in there. All right, guys. Well, that's all I got for now. Let me know what you think in the comments below, and I'll see you all soon.